Did you know that you can be discriminated against by someone who is actually trying to not discriminate against the discriminated against?
Yes.
I've been reading up on the case University of California versus Bakke. It seems like the university was just trying to protect the rights of minorities.
Yes.
And Bakke was just trying to keep from being discriminated against.
Well, yes.
But wasn't he a middle-aged white guy?
Yes.
Is that all you're going to say?
Yes. Unless you say something that isn't true.
But what if I want to hear the rest of the story?
Then just ask.
Professor, will you please tell me the rest of the story?
Yes. In 1972, Alan Bakke was a 32-year-old NASA engineer.
Wait, he worked at NASA? So he was pretty smart, huh?
Oh, he was. He earned both his bachelor's and master's degrees in mechanical engineering. He also served our country as a captain in the U.S. Marines.
So why was he applying to medical school?
Well, Bakke had an interest in medicine too. After working part-time as a volunteer in an emergency room, he went back to college to take the courses required for applying to medical school. He took courses in biology and chemistry and scored a 72 on the MCAT entrance exam.
Is that good?
72 was 3 points higher than the score of the average applicant at the University of California, Davis, where he applied to medical school.
I see.
Bakke also maintained a 3.5 out of 4.0 GPA throughout his college career, which was far beyond what he needed for entrance into the program.
Oh, really?
Yes. Qualified candidates only needed a grade point average of 2.5 or above to be admitted through the regular admission program.
And he had a 3.5? Wow, he knocked that one out of the park. But wait, what do you mean by a regular admission program?
Well, the university had created 2 different admission programs, a regular admission program and a special admission program.
What was the difference?
The regular admission program was open to all eligible candidates with an undergraduate GPA above 2.5.
Okay.
While the special admission program, designed to increase the number of minorities and disadvantaged students admitted, did not require a minimum grade point average.
I see.
The medical school reserved 16 out of 100 spots each year for minorities and disadvantaged students. These included Blacks, Chicanos, Asians, and American Indians, according to their policy.
Wow. And how many people applied for these 100 spots?
They received approximately 3,700 applications each year.
That's pretty fierce competition.
Indeed.
But that sounds pretty nice. I mean, helping out disadvantaged people?
It was a nice idea. However, it was perceived by some as discrimination against those who were not minorities or disadvantaged.
People like Alan Bakke?
Yes.
And Bakke applied twice, correct? In 1972 and 1973?
Yes, he did. And despite his exceptional educational record, he was denied admissions both times.
So what did he do?
Well, he took the school to court.
Of course he did.
In June 1974, Bakke filed suit against the university in Yolo County Superior Court. Bakke's lawyers requested that he be admitted to the medical school because both his test scores and grades were better than those of others who had been accepted. Counsel for the university argued that Bakke would not have been admitted even if there had been no special admission program for minorities.
Okay, but all Bakke needed to do was to show his test scores and grades to prove that argument wrong, right?
Right, and so he did, claiming he was a victim of reverse discrimination.
Whoa, big word.
A big idea. Bakke alleged he was rejected because of his race, thus violating the Civil Rights Act of 1964 and the Equal Protection Clause of the U.S. Constitution's 14th Amendment.
Wait, slow down. That's a lot of information. Please explain further.
The Equal Protection Clause is part of the 14th Amendment, one of 3 amendments adopted just after the Civil War. It guarantees that no state shall deny to any person the equal protection of the laws.
In English, please.
Each person should be treated equally by the law. It was created to help protect the newly released slaves after the war. However, in 1974, it was used to help protect the rights of a white male.
Who was being discriminated against because of the color of his skin. Now, what was the other argument you mentioned? Something about the Civil Rights Act of 1964?
Yes, part of the Civil Rights Act of 1964 was a government initiative commonly referred to as affirmative action. Created initially to improve opportunities for African Americans, affirmative action implemented policies and procedures that gave preferential treatment to women and minorities. This affected job hiring, college admissions, and other situations. Since Bakke was not in this preferred group, he claimed he had suffered reverse discrimination based on race.
And what did the California court say?
The Supreme Court of California ruled in a 6-1 vote that the university could no longer use race in its admissions process.
No applicant may be rejected because of his race, in favor of another who is less qualified.
The court further ordered the university to show proof that Bakke's application would have been rejected regardless of race. The university was unable to do so. Therefore, the court ordered the university to accept Bakke into its medical school.
Did the university appeal?
Of course.
What did the U.S. Supreme Court say?
In an 8-1 decision, the justices declared affirmative action to be constitutional, stating that race could be one of the factors used in college admission policies. Nevertheless, they agreed that Bakke should be admitted because they held that the use of racial quotas was prohibited.
So no more reserving a certain number of spots for minorities?
Exactly. Since then, the court has limited the scope of affirmative action nationwide, with several states banning programs based on race altogether.
Interesting.
Now, speaking of interesting, what other cases are you interested in learning more about?
It's up to them.